right, here we go. Good morning, everybody, and welcome to our continuing legal education seminar. It's police report writing, recovery of evidence from a warrantless search. Robert Ramsey is my name. My co-conspirator here is Matt Rogalski, who's an assistant prosecutor and a career prosecutor at that, with the Mercer County Prosecutor's Office, okay? In terms of your materials, what I'm going to ask you to do, just follow right along. We'll put everything up on the screen and take your notes on your materials. Any questions along the way, that's perfectly fine, and then we'll do our thing, okay? Let me see. Everybody can see this. Okay, starting off with just motions to suppress in general, I think I wanted to kind of tell you from just the perspective of defense counsel and prosecutors that many times the motion to suppress in a case, in a criminal case, is in fact the trial. And by that I mean that the evidence of guilt is fairly overwhelming, and the only issue deals with whether or not the evidence that was seized from the defendant is going to be admissible against him at trial. So if the motion to suppress gets heard in court and the judge determines it, many times that's dispositive of the entire case. So if the judge denies the motion to suppress, the defendant will plead guilty, and that'll be the end of the case. And by the same token, if the evidence winds up getting suppressed, it normally won't leave the state with sufficient evidence with which to go forward on the case. Now, there's advantages for doing it this way from the state's perspective in the sense that their burden of proof typically is lower than you'd have to do at a trial. In other words, at the motion to suppress, for most exceptions to the warrant requirement, the burden of proof is going to be by preponderance of the evidence, just a kind of a 50% level of evidence that they'd have to present. If the state can present 50% of the credible evidence, the judge is supposed to rule in the state's favor, as opposed to having to prove every element of the offense beyond a reasonable doubt during the course of a trial. The burden of production normally is going to be on the state in a warrantless search situation, meaning that the state is going to have to go forward and show that the seizure of the evidence was justified by one of the recognized exceptions to the warrant requirement. Everybody got that? So, I guess what I'm trying to explain to you is the following, is that if the motion is granted, many times that's going to be the end of the case. Do you agree with that, or do you think that that's
and a lot
wrong?
of times people don't understand that, and police officers don't prep for it. Police officers are most often prepped for trials. You go in for an hour, you go in for an hour and a half sometimes, depending on the necessity of the facts of the case. But you walk into a motion to suppress with a 15-minute, BS session with the prosecutor, shake his hand, tells you who he is, you take a look at the files for 5 minutes. That is a huge mistake, because as Bob is saying, many of these cases are made or broken in a motion to suppress. And although, practically speaking, it's impossible to spend a great deal of time doing a motion to suppress prep, you must prep for it. You walk in cold, you're going to say stuff you don't know, you're going to compromise the case later on. Most of the time, motions to suppress are filed simply to give the defense an idea of where you're going in the case itself.
This is where you all kind of come in. His former boss and my dear friend, many of you may know Bill Zarling. Larry, you know Bill Zarling, right? Okay. Bill used to say to me, you ought to file the motion to suppress in every case. It's just one page, just one single page you have to file. Well, that may be, but as a practical matter, lawyers, defense attorneys have better things to do than follow through on needless and idiotic motions to suppress that have no merit. The reason motions to suppress get filed by defense attorneys is because of police reports. That's the reason. You'll get the discovery in, you read over the police report, and if you're an experienced attorney reading through the report, you're going to see an error that the officer has made, either because the officer did something he didn't know what he was doing, or, as more likely will occur, the officer did everything fine, but wrote a lousy report. Either he left something out of the report, didn't explain something clearly, or just kind of bollocksed it up in such a way that he didn't properly express what the facts were that occurred. This leads to two difficulties. Number one, there's a motion to suppress filed that shouldn't be filed. And number two, when you get to court, the officer is going to have to explain what he did and why there's these deficiencies in the report. Conversely, I'm just going to tell you this from a personal standpoint. If I'm reading over a police report and I don't see any exceptions to the warrant requirement there and the officer's got everything covered, I'm not going to waste my time filing a motion to suppress evidence. There's a separate issue, too, and that really I want to leave to you to talk about. It's what do you do when you get a lousy report and you got a motion to suppress evidence you got to deal with?
One thing you got to remember, when I get a case, in my cute little beige files, I don't know what most of you guys I think are from Middlesex, We get them in the beige files. The facts that we understand as prosecutors are the ones you gave us. 99% of the time, unless it's a homicide or some major case, I'm not going to call you up and say, golly, gee, about this. Did you look left? Did you look right? Did you do this? Did you do that? Most of the time, our decisions for purposes of pleading a case out because of a bad motion to suppress are based on the paperwork you give us. Because if we try to track you down with your 72 shifts that you work, and you're going to call us back at 3 a.m., blah, 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 and by the time we get that information back, it's often moot. So the only information we go by is in your reports. So if your report sucks, then we translate that as the case sucks. Unless, again, it's a homicide or some major bank robbery or a sexual assault, then you're going to have that follow-up. But by and large, the normal case, we go by what you give us.
Which could also lead to, I guess, sometimes you take a position on a case which really has merit, but the report is so bad, you don't want to go through with it.
We don't know about that. The prosecutor's office never finds out because you guys don't call us up a week later and say, hey, why did this go bad? Why did you plead this? Why didn't you? I get a handful of calls a year from police officers post-plea, and rarely do they ever ask me about motions to suppress. So you guys don't get feedback as to the weaknesses inherent in your reporting, which caused the weakness in the motion to suppress, which caused the plea, or the misinterpretation of the case by me of facts that aren't clearly related in the reporting. Either one can result in the same thing, a plea to a guy that doesn't deserve one.
So as a starting point today, what I'd like you to do is keep the following kind of basic rule in mind, that when you're writing a report or you're training someone on how to write a report dealing with the recovery of evidence from a warrantless search, you've got to be sending a message to the primary audience. I mean, over and above the sergeant and the other people who are going to be reviewing the report. And the message is, this guy is guilty, all right? He did it. Not only is he guilty, but we have the evidence to prove that he's guilty, and I have satisfied all the requirements I have to for the recovery of this evidence. And if you start with that proposition thinking that there's a defense attorney somewhere down the line who's going to read this, so when you're preparing the report, this is kind of in the back of your mind, you're going to be surprised at how few times you're going to be called into court on a motion to suppress evidence. Because again, no one's in the business here wasting time unless you're some kind of ideologue. You have more fruitful things that you can do with your time and better ways to represent clients than filing motions to suppress that are going nowhere. Now, just a couple of basic things, which I really don't want to spend a lot of time on because everybody's just kind of self-explanatory. In terms of professionalism, the format you utilize, of course, can be dictated by your department, but grammar, spelling, presentation, it really does, in fact, make a huge difference, especially in the areas of grammar and spelling. It just gets very, very embarrassing in court when you have to kind of deal with those issues. I know in drunk driving cases, frequently you'll get up and talk about how the defendant couldn't say the alphabet, and then you cross-examine the officer and say, well, officer, how do you spell alcohol? Does it really have 4 L's in it, Were you intoxicated, officer, when you wrote this report? This kind of stuff. It's just embarrassing. It's completely unprofessional and not in keeping with the really high standards of police professionalism these days. Now, I told you a moment ago, the substance of it, forgetting about the form for a moment, the substance has got to communicate guilt, all right? That's the key thing that you're going to do when you write your report. I tried to come up with an acronym that we could utilize to kind of remember this, and I've come up with the word JETS, and we'll talk about what each element is, but I just want to give you kind of some prefatory discussion. When you're doing your job on the street, you do your job on the street, okay? You do what you have to do to get the job done. And you shouldn't be thinking about writing reports at that time. You should be thinking about accomplishing whatever mission you have to accomplish on the streets. Lots of times, you don't have time to be thinking and analyzing and going through all these nice legal maneuvers that people do in court. It's a different world. I wouldn't for 1 second pretend to tell you how to do your jobs as law enforcement officers, okay? But just do what you have to do and get the job done. When you're back later on in the police station where things are calm and nobody's fighting with you and screaming at you or crying or bleeding on you or whatever it may be, now you're in a situation where you've got to kind of account for what you did, all right? If it deals with a seizure of evidence following a warrantless search, I'm going to suggest that you keep 4 things in the back of your mind when you write your reports. You can remember them by this acronym JETS. All right, J, what exception to the warrant requirement justified the search that I undertook? That's the first thing you should be thinking about. I conducted a seizure of evidence from this individual. What exception to the warrant requirement justifies that?